Come on, go live. There we go. Hi, everyone. We're going to get started in just a moment. Today, we have Cristina Dacchille Freeman, MIRA's senior immigration attorney. She's going to talk to us about some frequently asked questions around immigration law. So welcome to Friday Field Reports Live. Please share your questions in the comments, and if we can't answer you here today, we will follow up after the episode. So now I'm gonna turn it over to Christine. Get out of here.
Good afternoon, everyone. My name is Cristina Dacchille Freeman, and as Laura said, I am a senior immigration attorney at the MIRA Coalition. I'm here today to answer some of your questions about immigration law. If you're listening and you have any questions, feel free to put them in the comment section, and I'll do my best to answer them before we sign off today. In the meantime, we had 5 questions submitted before today's broadcast that I would like to take the opportunity to answer. So we're going to dive right in with question number 1. The question we received said, if people want to self-deport, what is the exact process? Are most people being sent to their country of origin, or are some of them being sent to random countries? I'm actually going to answer the second part of that first, because it's the easier part to answer. Most people are being sent to their country of origin. Some people are being deported to third countries who have agreed to accept US deportees. If you are self-deporting, which we'll talk about what that means in just a minute, then you are actually choosing the country where you go. So what is self-deportation exactly? When people talk about that, what does it mean? And we can go to the next slide. Thank you. So self-deportation is an option that's being talked about right now in the media a lot because it's an option that's been encouraged by the Trump administration, mostly to scare people into leaving the United States to avoid the risk of ICE detention. Leaving the country voluntarily may be a good option for you and your family, but it might not be. So before you actually take the step to leave the US, it's really important that you speak to an immigration attorney to protect your rights. Why is that? Number 1, because lots of people have legal options for staying in the US. And if you leave, you won't be able to pursue those options. Second, self-deportation carries some risks. And over the course of the next few minutes, we're going to talk about what some of those risks are. It is important to know that if you leave the country while you have open removal proceedings pending against you in immigration court, those proceedings may result in a removal order and a 10-year bar on reentry to the United States. So we'll talk about how to safely self-deport if you're in removal proceedings. Also, really important to remember, if you do self-deport, or if you do choose to move voluntarily from the US, keep records of your travel so that we can use them later to prove the times that you were here and the times that you left. Okay, so when we're talking about self-deportation, the first option that comes up often is something called voluntary departure. Sorry, we're going to talk about the CBP Home app first. Got my slides a little mixed up. So CBP Home app, this is something that you might have seen in the news a lot lately. It's been getting a lot of media coverage. It's a way for an individual who is in the US unlawfully with no pending criminal charges to ask the federal government for help leaving the US voluntarily. The federal government says if you use this app, you'll get 2 main benefits. The first is help paying for and booking your travel back to your home country. And the second is $1,000 upon confirming your departure from the United States. This is being done in large part because this is a much cheaper option for the United States government than paying for each individual to have full hearings in immigration court. On average, in order to charge someone with being in the US unlawfully and then give them a full immigration court proceeding, including appellate relief, can cost the government up to $17,000 per individual. So by paying for the ticket home and giving each individual $1,000 upon confirming departure, it's significantly cheaper. But is it better? Not necessarily. There's some risks involved with using this options. Number one, if you have been in the United States for more than 6 months without legal status, and you choose to use this option to self deport, it is very possible that you will face a 3 or 10-year bar on reentry to the United States. So it'll be much harder to get back. And there's no guaranteed path back to the US in the future. Also, if you have a pending application, like a pending asylum application, leaving the United States will be considered an abandonment of that application. So you'll no longer get the opportunity to apply for a benefit. The other option for formal self-deportation is something called voluntary departure. And we'll take a look at that on the next slide. Voluntary departure is a formal request to an immigration judge by someone who is currently in immigration court proceedings, who has no serious criminal record, and who can show that they have a passport and the funds they need to travel home on their own. Basically, this is a way for someone who's in removal proceedings to go to the judge and say, look, I don't want to pursue my case anymore. I want to be given the opportunity to leave voluntarily. And if the judge grants voluntary departure, they will give the individual a date by which they have to leave the country. And as long as the individual departs on or before that date, no removal order will be issued by the judge, meaning we won't trigger that 10-year bar to reentry that having a removal order executed can lead to. What are the known risks to voluntary departure? Well, there's a couple that I think are worth knowing. And again, always, always, always consult an immigration attorney about your specific circumstances. This information is just meant to be general information, and your case may have specific circumstances that make this information less applicable. The general risks to voluntary departure involve, first of all, a failure to depart on time. A lot of folks decide they want voluntary departure, they take a voluntary departure order, and then something changes and they're unable to leave in the time they said they would. If that happens, the consequences can be really severe. Not only will your voluntary departure order convert into a removal order, but you can also be hit with monetary fines, and you'll be barred from re-entering the US or applying for certain immigration benefits for 10 years. Even if you depart on time, there's usually a 3-year bar on re-entry to the United States. And those 3 and 10-year bars that we talked about, based on unlawful presence here in the United States, those will always apply. If you've accrued more than 6 months of time without status in the US, you're going to be barred from re-entering the US for 3 years. If you've accrued more than a year of unlawful presence in the US, you'll be barred from re-entering for 10 years. And then finally, the last known risk involved with voluntary departure is abandonment of pending applications with no guaranteed path to return. So in summary, what do we want to know about self-deportation? We want to know that, number one, it's not for everyone. Consult an immigration attorney before you take any actions. Number two, there may be consequences and risks involved in seeking voluntary departure or CBP Home App self-deportation that include bars on reentry, monetary fines, legal penalties, removal orders, lots of things that really will depend on the individual facts and circumstances of your case. Finally, if you do decide that voluntary departure or CBP Home App or just getting up and moving is the right course of action for you and your family, keep records, because the more records you have, the easier it will be later if you're trying to re-enter the US to prove when you entered and when you left. So that's just a little bit on self-deportation. We're going to move on to our next question. The next question we received said, I don't understand. Why aren't immigrants receiving due process anymore? Was this always the case before Trump was in office? This is a great question and one that we get a lot. I think it's worth starting with a broader question, which is, what is due process? What do we mean when we say due process? Due process is guaranteed by the United States Constitution, by the Fifth and 14th Amendments. The Fifth and 14th Amendments guarantee fair treatment under the law for all people, not just US citizens. And this is important to remember. There are some rights in the United States Constitution that are limited to US citizens, but due process isn't one of them. Due process is supposed to apply to every single person in the US. And the reason is to protect them against unlawful government action. If the government is following its own rules and the rules set forth in the Constitution, then the government must tell a person what it plans to do to them and give them a fair chance to explain their side in court before interfering with that person's life, freedom, or belongings. In other words, it makes sure that the government just can't come and take you away without giving a reason, presenting evidence, and giving you the opportunity to challenge that evidence in a fair and impartial court setting. So that's due process. When we're talking about due process in the immigration context, things get a little bit more complicated. One thing that I think is important for folks to know is that deprivations of due process have been routine in immigration court for a long time, long before Donald Trump ever took office. In fact, due process violations have occurred on a massive scale in our immigration legal system. And it's not just immigration attorneys like me who are saying that. Uh, Immigration Judge Dana Lee Marks, when she appeared on The Daily Show, said, in essence, we're doing death penalty cases in a traffic court setting. And I really appreciated that perspective as an attorney who's been in immigration court and seen the chaos that unfolds there. The stakes are high. Someone who's being forcibly returned to their home country is being separated from family members here in the United States, having property here in the United States taken away from them or taken out of their circle of control, and being sent back to countries where they may face significant hardship, persecution, and in some cases, even death. So the stakes are really, really high. But the procedural protections in immigration court and the environment of immigration court often feel more akin to a traffic court setting where cases are being decided very, very quickly in a chaotic environment, often without attorneys present. So, what are some of the common due process issues that we saw even before Trump? One was a lack of legal representation. Believe it or not, there's no right to a free attorney in immigration court, even for kids or individuals who are being detained by our government. That's a problem because studies show that people with lawyers were 5 to 10 times more likely to win their cases. But most immigrants don't have lawyers and are forced to represent themselves. Another common due process issue that has always existed in immigration court are inconsistent decisions where the outcome of a certain case is dependent on the specific judge you get or the regional court in which your case is being appealed. So, for instance, there are different rules regarding eligibility for asylum in the First Circuit, where we are in Massachusetts, than there might be in the Ninth Circuit or 11th Circuit over on the western half of the country. This is an issue because it means that it's very hard to predict what the outcome to any immigration trial might be. In fact, one thing we know just looking at the approval and denial rates of individual judges around asylum is that those grant rates varied from less than 10% approval for some judges to over 90% approval for other judges. The cases that they're seeing are all very similar. So discrepancies of that size in the percentage of approvals really signify that the judge's personal opinions and bias are often reflected in the outcome of their cases. Another common due process issue that has always existed in the immigration system is barriers for those who are in detention. People who are held in immigration detention centers often lack access to counsel, legal information, or even working phones. Many are limited English proficient, and they don't understand their rights or how to request bond or relief. And these detention centers may be hundreds of miles away from any lawyer or legal service provider. Another common due process issue that existed long before Trump took over was inconsistent or poor interpretation and translation services. This can cause a massive problem for folks in immigration court because, of course, most cases hinge on the credibility of the person seeking a benefit in immigration court. But how can a judge believe you if they can't accurately understand what you're saying? Interpretation for folks who speak rare languages or indigenous language speakers often don't have appropriate interpretation in court. And many times, mistakes in translations can lead judges to deny otherwise credible claims. Another due process issue that has always existed is the pressure on immigration judges to rush through cases. We call these case completion quotas. In other words, each immigration judge is expected to complete a certain number of immigration cases per year. But how can they do that when, on average, even before Trump took office, they were balancing each judge dockets between 1,500 and 3,000 cases? Think about that. One judge having to make a decision in a year about 1,500 to 3,000 individual cases. Can they really be giving the due process protections and the attention that each of these cases need to make fair decisions under law? Or is the process itself flawed? In immigration court, there's also limited access to evidence and records. Often, you are not given copies of the evidence that the government has or that they intend to present against you. And if you are able to get your record, it's only through filing Freedom of Information Act requests or record requests with the US government. That can take months or even years to get those records, giving you inadequate time to prepare your case for immigration court. Finally, there has always been an inequality between detained and non-detained dockets. Hearings for individuals who are detained are often rushed. They will often have a hearing within days or weeks of arrest. Those hearings are often conducted by video, and those individuals have a difficult time finding representation because the process is moving so quickly and so many attorneys are overburdened and at capacity. Those who are in non-detained cases, on the other hand, often face very long case processes, cases that will take 4 to 7 years from the time they're started to make a decision. This means that witnesses, evidence, testimony that you may want to offer, all of that is going to have to wait 4 to 7 years, which can lead to inaccuracies, witnesses moving away, evidence that becomes unavailable, testimony that you've forgotten because it's been so long since you first started your case. So detained and non-detained cases are handled so differently, but both can lead to this outcome of being deported from the United States, which, as we've said, for some people is a death sentence. So that was due process in immigration court always. It's always been a place where due process has struggled to be fulfilled. But there have been some changes. So what exactly has changed under the second Trump administration? Number one, they're trying to bypass the immigration courts altogether. There's been a huge expansion of something called expedited removal, which is when the US government can deport you without first giving you a hearing in immigration court. This used to apply only to a small group of people, but the Trump administration has changed the rules and broadened who this expedited removal process can apply to, such that there are now many individuals who are being denied a hearing in immigration court and rushed through a removal process. We've also seen the Trump administration strip immigration courts of jurisdictions to make certain decisions. A key example of this was just handed down by the Board of Immigration Appeals that said specifically, immigration judges do not have jurisdiction to question or redetermine custody status for ICE detainees. In other words, if ICE arrests someone and puts them in a detention center, that immigration judge no longer has the jurisdiction to determine whether or not detention is appropriate and whether or not bond should be granted. That's a big problem because it means that we're taking power away from the immigration courts and we're bypassing it and giving more power to enforcement agents. The Trump administration has also used the Alien Enemies Act to detain and deport people based on very little evidence, with little to no opportunity to contest the charges in court. Under the Alien Enemies Act, if the government classifies you as a terrorist or someone with ties to a terrorist organization, you may never get your day in court. You may be deported and sent out of the United States without ever having the opportunity to hear the evidence against you. That is unconstitutional. Another major change that the Trump administration has affected is making immigration court even more difficult to navigate than it was before. So on the prior slide, I talked to you about all of the challenges that already existed in immigration court, but if you can believe it, it's gotten much worse. Number one, the administration has cut funding for critical legal services that help people avoid detention and removal. And that includes free representation program for unaccompanied kids. It also includes legal education programs that only seek to inform people of their rights in immigration court so that if they can't find an attorney, they can represent themselves. Think about that. We're taking away government representatives or legal representation for kids who are here without parents and forcing them to represent themselves in complex immigration legal proceedings. And we're not giving anyone information about what to expect in immigration court or how to protect your rights in immigration court. We're just throwing them into a complicated system with no support or help. A second thing that happened that has really interfered with an individual's ability to navigate immigration court is an executive order that was issued threatening immigration attorneys who bring frivolous cases. The Trump administration is trying to scare immigration attorneys and advocates so that fewer of us decide to challenge these cases in court. Understandably, some attorneys are anxious about being targeted in this way, which of course is exactly what the Trump administration wants, so that individuals are forced to navigate complex immigration proceedings without the help of a legal representative who can protect their most basic constitutional rights. The third thing that the Trump administration has done to make immigration court even more difficult to navigate: firing immigration judges at a time when we have more cases pending in immigration court than ever before. So you'll remember I said before Trump, immigration judges often handled 1,500 to 3,000 cases each. Well, now we have a system where there are fewer than 700 immigration judges in the United States for more than 3 million pending immigration cases. That means that each judge would need to hear 4,700 cases just to address the cases that are currently pending. That's an impossible scenario, and certainly not one that's conducive to protecting our constitutional rights. Finally, there is a disregard for basic constitutional rights by ICE enforcement agents, and we've all seen this. We've seen it on the news. We've seen it in our neighborhoods, our communities, and it is really, really horrifying to watch, right? We've seen folks whose doors have been kicked in despite the fact that agents don't have warrants. We've seen people racially profiled on the street who are stopped by ICE agents simply because of their skin color or the language that they're speaking. This complete disregard for basic constitutional rights by ICE enforcement agents has undermined our ability to have any faith in the justice system or the Constitution itself. So that's what's changed and that's what's new. I wish I had better news for you on that front, but I do want to assure you that attorneys and organizations like the MIRA Coalition are fighting every day to challenge these actions by the government. Okay, moving on to the third question that we received. I still get confused between asylee, refugee, and all those terms. If you have one of those titles, doesn't that make you legal in this country? Why are these people also being deported? That's a great question and one we get really frequently. The answer lies in the definitions of refugee and asylee. And when we're talking about the definitions of asylees and refugees, we want to distinguish between the legal definitions of those terms and the common use definitions of those terms. Because legally, both of those terms actually refer to individuals whose applications for refugee or asylee status have already been approved. But in common use by the media, by advocates, by immigrants themselves, by all of us, we often use these terms to refer to individuals who are applying for one of these benefits or seeking one of these benefits, but who haven't yet been approved. Now, historically, individuals who had pending applications for asylum status were protected from removal until a decision was made in their case. But what we see happening really frequently in the immigration courts is that the current administration isn't necessarily honoring that. People are having their immigration cases or asylum applications dismissed from immigration court because they haven't filled out the form correctly, or people are being deported from the country before they actually have an opportunity to present evidence on their immigration case. Looking a little bit closer, though, at the legal definitions of refugees and asylees, I want to explain to you what it is and what the differences between those two words are. So, both refugees and asylees have some things in common. They fear persecution in their home country based on race, national origin, religion, political opinion, or membership in a social group like their gender or their sexual orientation. Both refugees and asylees can live and work legally in the United States, and they're eligible to apply for a green card after 1 year. If they get that green card, then they can apply to become a US citizen in the future. So once status as a refugee or asylee is granted, it does put you on a pathway that will ultimately result in citizenship. The differences between refugees and asylees have to do with where they apply and who decides the case. Refugees apply for status outside the US before they enter. Usually, or I shouldn't say usually, often this happens in refugee camps where people have been displaced from their country due to ongoing violence or persecution, and they find themselves in a refugee camp abroad operated by different international partners, including the United Nations. The individual who wants to seek refugee status can apply to the United Nations Commission for status as an international refugee, and then they can request to be resettled in the United States, and that decision is up to the United States government. Asylees, on the other hand, flee their country of origin however they can, often with no opportunity to first get to a refugee camp or a safe country. They come right to the United States seeking safety, and when they're at the port of entry, they ask the officer to give them the opportunity to seek asylum. That asylum decision is then made either by United States Citizenship and Immigration Services, USCIS, or by an immigration judge. So, in a nutshell, that is what it means to be a refugee or asylee. But again, remember that much of the time it's the common use definition of those terms that are being referenced in newspapers, magazines, and in the media. Moving on to question number 4. Why don't we hear anything about South African refugees? Are they really refugees? Now, this is an interesting tidbit for folks who maybe haven't been paying as much attention to the media. At the beginning of his administration, President Trump entered into a controversial US government program that fast tracked resettlement for some white South Africans, particularly those known as Afrikaners, based on claims of racial discrimination and violence. Many observers argue that these individuals don't meet the typical criteria for refugees and that their expedited process differs significantly from those for other nationalities who are fleeing conflict. South African refugees prior to the Trump program were few and far between. And that's because refugee status requires individual persecution, not general crime or poverty. South Africa is not currently at war, and it does have a functioning government and functioning legal institutions, which means that very few of its citizens meet the traditional definition of a refugee facing persecution by their government. Only a handful of South Africans were granted refugee or asylum status in the US each year, and those received very little media coverage, due in large part to the fact that there were bigger refugee crises happening throughout the region. In fact, South Africa was more frequently a host country for refugees rather than a source of refugees. South Africa receives thousands of refugees each year from Zimbabwe, Somalia, and the Democratic Republic of Congo. In fact, in 2023, the South African government accepted more than 67,000 refugees, meaning its government promised to protect 67,000 new immigrants to their country. In contrast, the US refugee program is currently suspended under the second Trump administration. In 2025, prior to the suspension of the program, we admitted only 27,000 refugees. So when you think about the refugee burden being shared across countries all over the world, South Africa is actually stepping up to take twice to 3 times the number of refugees in that the US has this year. All right, we're going to move on to our last question, and then I'm going to address some of the questions that have come up in the chat. So the last question we received before this was, for an average person who doesn't know anything about immigration law, where is a good place to start learning? I love this question because, frankly, even as someone who's been practicing immigration law since 2007, I still find myself curious and interested in learning more each day. And each day I encounter facts and information that I never knew before. It's a really complicated field of law, and it can be a hard one for beginners to break into. So, where do we start? I have a few recommended resources. First of all, there's 2 websites that I would highly recommend because they have very easy to read, accessible information on what I would call Immigration 101 or immigration basics. The first is our own website, the MIRA Coalition. If you click on our resources tab, you'll see a ton of material that will educate you on many of the issues facing immigrants today. If you are looking for an overview of Immigration Law 101, the American Immigration Council has some great resources, and you can see them there on the screen now, where you can learn all about the immigration system, the history of how it was formed, the laws that exist now, the places where we see challenges developing in the future. In addition to checking out these websites, I really encourage you to attend any training you can that's given by immigration experts. I've listed 3 organizations here that I know give some really excellent training on immigration basics, including the MIRA Coalition, the Immigrant Legal Resource Center, and Clinic Legal. All 3 of these organizations offer Immigration 101 trainings that are designed to educate non-attorneys about the immigration legal system and to understand how, as non-attorney advocates, they may be able to help. Attending trainings like that can be invaluable because it really will give you the opportunity to hear firsthand from experts what's happening and how you can help. Now, that's the last of the questions we got ahead of time. I'm going to go ahead and answer one of the questions that came up in the chat. And while I'm doing that, if you have other questions you want to ask before we sign off today, please go ahead and put those into the comments section so I can answer those for you. So the question we got in the chat, will USCIS start notifying people that they can attend master court appointments through Zoom? We only know about it by talking to pro bono lawyers. Actual paid lawyers never told us about it and wanted $2,000 to appear. There's a lot to unpack in that question, so I'm going to start at the beginning. First of all, I want to make clear the difference between USCIS, United States Citizenship and Immigration Services, and Immigration Court, also known as the Executive Office of Immigration Review, or EOIR. USCIS has jurisdiction over applications filed by individuals in the United States who are not in immigration court removal proceedings. So they're not going to notify anyone about their rights in immigration court because that's not what they do. Those aren't the folks that they are working with. The Executive Office for Immigration Review, which is the technical title of the Immigration Court, they're the ones who are in charge of notifying people that they have hearings coming up and giving them the information they need to appear before a judge in their case. Now, the question here is, will the government start notifying people they can attend master court appointments through Zoom? This is a tricky question. First of all, the immigration court doesn't use Zoom. It uses an online video platform known as WebEx. Second of all, you don't have a right to attend any court hearings remotely by using WebEx. Each judge is given the individual discretion to decide whether or not they will permit the people appearing in front of them to appear online instead of appearing in person in the court. Some judges prefer online hearings and will give anyone the ability to appear for a hearing online. Others won't. In fact, if you show up online and not in person, you could be at risk for what's called an in absentia removal order, which is a removal order that's issued when you fail to show up for your immigration hearing. And the reason the judge can do that is because technically the default position of all hearings is in person, meaning if an individual didn't get permission from the judge ahead of time to appear online and they didn't show up in person, the judge can order them removed even though they tried to sign in using the online platform. This is why it's really important to defer these questions to attorneys. Paid or unpaid, we have an ethical responsibility to inform clients of the rights that they have. There is no right to a virtual appearance in immigration court. Some courts, like the courts here in Boston and the courts in Chelmsford, Mass., have policies court-wide that suggest that remote appearances via WebEx are perfectly permissible. Other courts, like courts in Miami and San Diego, for instance, have judges who will issue in absentia removal orders to folks who appear online instead of in person. And so you really need to check with individual lawyers and individual courts to figure out if the person is allowed to appear online. And if they're not, then the immigration lawyer needs to file something called a motion for remote appearance, which is a formal written request to the judge for permission for someone to appear online instead of in person. I know that's a lot of information, but I hope that helps answer your question and helps you understand some of the complexities in immigration court and the misinformation we find ourselves subject to. Someone who's only ever attended immigration court proceedings in Boston or Chelmsford might interpret the ability to appear online as a right because they see it being granted to everyone. But ask practitioners in courts like Miami and San Diego about the same, and they would tell you it's a special privilege only extended to a few. This is another example of inconsistent decisions and policies in our immigration court system that chip away at the very nature of due process, which says that we should be able to predict what the law is going to say in any given case. I don't think we have any other questions in the chat. You're going to get a couple more minutes opportunity to pop those in, and I'm going to spend a little bit of time just talking about some opportunities for you when it comes to helping protect immigrants in Massachusetts. The first one that I want to offer, Laura, if we can go back one slide, has to do with our campaign, Protecting Massachusetts Communities. And if you see the QR code on the screen and you want to go ahead and use your phone to click on that QR code, you'll see that we're asking individuals to sign a petition to protect Massachusetts immigrant communities. If you believe that all individuals, regardless of immigration status, deserve dignity, safety, and equal protection under the law, then please, please, please sign this petition and pledge to stand in solidarity with our immigrant communities and demand policies from our government that uphold human rights, ensure equal access to resources, and foster a future where all individuals, regardless of status, can live free from fear and injustice. So please, if you're able, go ahead and sign that petition now. Another way that you can get involved is to volunteer at MIRA. And you can see that there is a link right here at the bottom of the screen where you can go to sign up to get involved with our citizenship services, voter registration drives, communications efforts, and public events. If you're interested in being more involved with MIRA, I encourage you to visit that link and get involved, because the more of us who show up and stand up, the better the chance that we all have for a future where immigrant communities are celebrated and protected rather than demonized and targeted. I want to thank you all for tuning in today. Next week, stay tuned to hear MIRA's Executive Director, Liz Sweet, talk about how children are impacted by immigration enforcement. That should be a really interesting talk. Please join us again next Friday if you're able, and thank you for taking the time to learn more about this issue. I hope that you all have a great weekend, and we appreciate you tuning in.